You're listening to The Voice of Russia in London. I'm Vivienne Nunes, and today we're discussing the British government's plans for so-called secret courts. Secret courts are what the media has called closed material procedures. Although secret courts makes a catchy headline, the official name gives more of a clue to what they really mean. Under a CMP, part of the case material would be closed from one party. That means they won't get to see all the evidence against them, and neither does their lawyer. Only a specially vetted advocate would have access to the material and then represent them in court. That might sound Kafkaesque, and it's got libertarians and legal experts up in arms. But the government says the precautions are necessary in cases that contain highly sensitive information relating to national security. And while the closed material procedures might not be ideal, at least they allow for some form of justice for cases that are currently settled out of court. Joining me to discuss this conflict between open justice and national security are the QC Lord Edward Foulkes, a member of Parliament's Joint Committee on Human Rights. Also in the studio is Keith Best, a former Conservative MP and the Chief Executive of Freedom from Torture, and Stephen Tall, the co-editor of the Liberal Democrat Voice. Gentlemen, thank you for joining me. I'd like to start with you, Lord Foulkes, because you've spoken in favour of closed material procedures. First of all, what sort of cases would be heard by CMPs if this legislation currently before Parliament is passed? And I see you've got a copy of the bill in your hand.
I have. It doesn't say what sort of cases, but the cases which would be under CMPs would be those that involve, in the government's view at least, revealing evidence. At least part of the case would involve consideration of matters where national security was involved. And in order to defend themselves properly, they would wish to rely on that evidence. They couldn't do so unless the proceedings were such that they were not seen and publicised in the normal way.
Don't the existing measures used to keep sensitive material out of the public domain, though, such as suppression orders or public interest immunity orders, suffice?
Well, the trouble with PII, although it works quite well, it puts the government in a dilemma, because if a judge decides that the material is too sensitive, balancing up that interest with the interest in open justice, the government can then say, right, well, we can't adduce this and we won't adduce it, but on the other hand, we can't defend ourselves without it. So they are then in a position where they have to settle. Similarly, if they are told that the balancing exercise doesn't result in a decision in their favour, and they have to produce this evidence, if they, the government, think that to produce it would conflict with their duty to protect the nation, then similarly they have to settle the case. So they're in a dilemma.
Stephen Tall, what's your response?
I start from the very simple principle, I guess, which is that we want to make sure that free, open justice is preserved. And the problem, I think, with secret courts, and you put your finger on it right at the start, was that it's not just a question of the court meeting in private, in camera, behind closed doors. There might be a good case. There often is a good case for that taking place. What is at stake here is the fact that crucial evidence, which would allow a claimant to contest their case, is not able to be cross-examined, to be tested, and therefore may be found not to be valid. And so you end up with the two pillars of justice, one of them being knocked down. And it does mean that you have the potential for claimants having their case rejected for reasons they have no idea why. And I think the principle of justice is that it should be open, free and fair for all. And if you have one part of a case known to one party but not known to another, that's a basic unfairness that no amount of amendments to the bill can actually make right.
Lord Foulkes, is that a basic unfairness that can't be overcome?
Well, I don't think anybody's enthusiastic about any dilution from the principles of open justice, and I'm certainly not. It does offend against most lawyers and most ordinary members of the public's idea of how justice should be done. However, the judge is going to have quite a lot of weapons at his or her disposal to minimise disadvantages, not only special advocates who are extremely competent and experienced, but also gisting and only ordering part of the evidence to be under closed material proceedings. And I think our judges are pretty good at trying to reduce any injustice that's caused by this. But I do agree that it's far from ideal.
Keith Best, your organisation works with victims of torture. Potentially they might be the sort of people who might allege the government has been complicit in that treatment. Isn't it better that those cases are held on some level rather than, as they are at the moment, just settled out of court?
Well, I think you have to go back to fundamental principles, as we've been talking about just a moment ago. One of those fundamental principles in the law is what's known as equality of arms. In other words, you have both parties in an accusatorial system who have access to the information. They can challenge that information on the other side, and the judge, if it's a judge court or a jury in a criminal court, although this only applies to civil courts, would have the right to adjudicate on where the truth and where the interest lies in those matters. Now, this fundamentally opposes that concept of the equality of arms, because it does mean, to put it in layman's terms, that one party would not know what is being ranged against them. And they would never know. They would never have the ability to actually hear that evidence, to be able to challenge it or whatever. And it fundamentally goes against the whole concept of what evidence should be allowed to be used. Now, you mentioned my organisation, Freedom from Torture. The Convention Against Torture specifically excludes evidence obtained under torture from being used in any proceedings. And so any evidence that is tainted in some way should not be used in proceedings. And the simple answer is to say that if the government cannot disclose this for a variety of different reasons, either because it might compromise their sources or it might compromise a particular intelligence officer or anything like that, then it should not be used if it cannot be disclosed to the other side. And I don't think the British public, let alone the lawyers, would feel comfortable about having a situation where it is in effect a government minister, an elected politician who sometimes has a lot to hide for very often legitimate reasons because of government, makes those decisions rather than a judge who is the arbiter in these matters. And I think at the end of the day, people have greater confidence and faith in a judge than they do in a government minister.
Last week, though, we saw an amendment passed in the House of Lords that would give the judge that discretion as to when to use a CMP. Is that not enough?
Well, I join with those who actually think that the recommendations from the Parliamentary Joint Committee on Human Rights is the right way to go, which doesn't throw out altogether these closed measures matters, but does actually allow in certain circumstances a judge to make that decision, which of course is what the situation is now with a public interest immunity application. A judge would decide whether that is admissible or not, and if the judge decides not, then it's denied to both parties, and that is the right way to proceed. I think where the government's got a problem on this one is that it's not just a lot of lawyers, it's actually distinguished lawyers like Philippe Sands QC, who's an eminent human rights lawyer. It's the president of the Law Society, the chairman of the Bar Council. We understand most of the Liberal Democrat Party, or at least certainly according to their conference, and a very large number of other people, let alone all the non-governmental organisations, and they are opposed to these measures for the reasons that we've been talking about.
We do have a distinguished Queen's Counsel here with us, though, and Lord Foulkes, you're in favour of it.
Yes, I'm in favour of it, subject to safeguards, because I do understand why people are concerned, and I'm concerned too. But given the safeguards which are already in the bill and those which have now been put in the bill as a result of the amendments, if of course they remain in there following the bill's review in the Commons, then it seems to me that the government, or indeed a claimant who wishes to rely on CMPs, is going to have to go through a considerable number of hoops to make sure that it is fair and appropriate, so that the risk of injustice is going to be kept to an absolute minimum. But the alternative is simply to pay out. And I don't think that the population, although they're not keen on secret courts for understandable reasons, are particularly keen on paying out large sums of money to claimants who may or may not have a good case. The problem is we don't know without a hearing.
You're listening to The Voice of Russia in London. I'm Vivienne Nunes, and today we're discussing the government's plans to introduce closed material procedures, or secret courts, to civil cases in issues relating to national security.
Let me just perhaps widen it out to another concept as well, and that is the government was going to hold, and reputedly is still going to hold, a public inquiry into allegations of torture under the last government through extraordinary rendition. Now, that's only been put on hold at the moment because of the criminal investigations that are going on in Libya, because it's come to light that some people who I'm sure at the time it was never thought would ever even form part of the government, let alone be some of the leaders of it, were actually going to be in a position to challenge what had happened to them as a result of actions by the British government. Now, the government again in that was seeking to limit the ability of the people who'd suffered as a result of that extraordinary rendition to be able to give evidence themselves, and certainly to challenge or to test the evidence of those whom they were alleging were complicit in their own torture. And yet, if you look around the world, every public inquiry, every person from the special rapporteur on torture, Juan Mendes, and others who've been involved in public inquiries will say fundamental to the inquiry being robust and ending up with evidence on which people can rely and conclusions on which people can rely has those distinct elements as part of it. And it's the same principle here. How can anybody have faith in a judgment from a court where it knows one party has not been able to challenge the evidence that in effect has been taken into account against them? I mean, that's fundamental to the flaws of this particular idea.
Lord Folkes?
I'm not sure that the analogy is wholly appropriate. The independent reviewer of terrorism, David Anderson QC, was asked to look at 3 sample cases to see whether or not, in his view, he was able to understand why the bill was proposed. And he concluded, and nobody doubts either his expertise or his independence, that some cases, of which these 3 were an example, were so saturated in sensitive material that they simply could not be heard in the normal conventional way. And this wasn't necessarily a question of covering up torture or anything of that sort, but simply for all the sort of reasons that we well understand, the government wasn't going to be in a position to bring this evidence out into the open. The government say, and I'm in no position to know whether this is correct or not, that there are an increasing number of these cases coming on board. And of course, it has to be said that if a claimant knows that they can make a claim and that the evidence to rebut it simply cannot be heard, it's something of an incentive for them to bring proceedings.
As a society, though, isn't it more important that we hear about the cases of alleged torture, even if they prove to be false, so that we can either dismiss these claims altogether or deal with them and move to eradicate it? Keith Best.
Well, I think that's right. I mean, at the end of the day, justice and people's confidence in justice, which is critical to the whole basis of the rule of law on which we build our society and the confidence people have in our society, can only be applied subject to certain caveats. And one of those caveats is that you can't just willy-nilly throw in evidence which is alleged by one party and expect it to be relied upon without that evidence being challenged. And that is, in effect, what is being proposed here. Now, there is a role for the special advocate that already exists in the Special Immigration Appeals Commission, where an advocate can see material but cannot then disclose that to that advocate's client. That is one way of dealing with it. It's not entirely satisfactory. I personally would like to see if this is going to go through, and I do hope Lord Folkes is correct that by implication that the government will not seek to reverse these amendments when it gets back to the Commons. But if it goes through in its present form, then I think something like a sunset clause, in other words, that this will exist for only a certain period of time and then be subject to thorough review as to how well it's worked, is an added safeguard that we would need to have here for people to have confidence in it. But I think you don't need me to tell you. It's something that you could find from anybody standing at a bus stop. The idea idea that a government minister decides what evidence goes into proceedings which the other person cannot see or understand or know about is something that is on the route to tyranny.
Just to pick up on that, I think it's also crucial then that we see the British role within international justice as well. If we are seen to be overturning 3 centuries of justice that is seen to be and is in fact fair, free and equal, then other countries which we often criticise rightly for their abuses, whether of human rights or of legal procedure, if they look at us and see that we have, as the bill originally proposed until amended last week, that government ministers could decide and in fact dictate to judges, the wording of the bill says judges must hold closed material proceedings where the national security can be invoked. If they can point to that as this is British justice and all we're doing is adopting a form of British justice, then that puts us in an incredibly weak position when it comes to arguing against regimes which ordinarily we would say don't have validity when it comes to due process.
Lord Folkes, is this too great a departure from British justice?
I don't think it is a radical departure once you have qualified it sufficiently. But I do, as I think I've acknowledged throughout our conversation, accept that this isn't a traditional way of doing things, and I don't think anybody has a positive enthusiasm for going this route. It's just a question of whether the circumstances are such that, with appropriate safeguards, it is a procedure which can be used in very limited circumstances, and I think the government, as I understand it, accepts that there are going to be very few cases which fall into this category. And I think we can expect judges to be extremely loath to be persuaded that this is the right solution. The government are going to have to be careful before invoking this and to make sure that they've got a really substantial grounds for doing so. So subject to that, I don't think that our reputation internationally will be damaged by this very limited and significant change, but not one which I think will cause us the sort of damage that's been suggested.
We are hearing a lot of opposition to this bill, but last week when the amendments were voted on in the House of Lords, a Labor proposed amendment to remove the scope for secret courts altogether was actually voted down 164 to 25. Is this sort of a redundant argument if so many people in the House of Lords and so many peers are saying actually we should have them in some limited form? Stephen Tall.
I think having read through the proceedings of the debate last week, it looks like most members of the House of Lords were trying not to kill the bill, but to see if they could reform it. And I understand that position, which is that a bad amended bill is better than a worse unamended bill. But it's not one that I share. I think certainly when this issue was very well debated, actually, at the Liberal Democrat conference in September, the overwhelming view was that there are certain fundamental principles here which you cannot overturn, and that the safeguards that are put in place, yes, they are better than not having them in place, but it doesn't alter the fundamental principle, which of free, fair and equal justice being eroded. And I just want to return briefly to, just to make it clear to anyone listening, that as it stands, it's not like there's a free-for-all. It's not like all these cases are heard in open court and then printed up in the newspapers straight away. There is the system of PIIs, of public interest immunity certificates, which means that judges can see this material and take it into account and then decide themselves whether or not it should be disclosed to either side, which maintains a fundamental principle of equality, that equality of arms that Keith Best was referring to earlier. So, in effect, they become government super injunctions, whereby not only can the evidence be suppressed, but even the news of that suppression is suppressed. So there is a way in which national security cannot be compromised in any way. And what the government has not yet been able to point to is a single case whereby PIIs, public interest immunity certificates, would not have been able to allow a case to be heard. There has not been a single case brought forward of that. And the special advocates who've pleaded to see the cases that the government put forward as case studies of where closed material proceedings are needed, they've been denied access to that. Now, that may be tradition, but when we're looking to uproot tradition, I think it's pretty important that we get people who are disinterested parties to look at the evidence and come to their own conclusion and allow members of the House of Lords and members of the House of Commons to give the benefit of their experience first.
Keith Best?
I was just going to say that clearly there is a problem here, which has given rise to the bill in the first place, for the government publishing the bill. I mean, I hope governments are not in the habit of putting forward things which have no basis, in fact, whatsoever. But I think one has to gauge what is the nature of the ill that is trying to be overcome by this bill. And I do not see, either in its extent or magnitude, it being of such sufficient weight as to justify a bill like this. And you mentioned the fact that the bill itself in effect remains largely intact because of that vote to which you referred. Well, I'm afraid the phrase, now they're ringing their bells but soon they will be wringing their hands comes to mind. Once a government, which after all is the government because it can command, sometimes not always easily, a majority in Parliament, publishes a bill and it goes through, it's very, very unlikely, and indeed it's constitutionally prohibited in the Lords, that it can be overturned in its entirety in any event. So it's not surprising that vestiges of it will remain, although heavily amended. But I still think fundamentally we need to look at what is the nature of the problem that they're trying to deal with. And I do not think myself that it is such that it justifies a departure from the present system.
Lord Folkes, is it better just to stick with the smaller evil of paying out some of those claimants, the small number of them that there are at the moment, rather than making such a transformational change to the law?
Well, of course, the difficulty is that it's all very well saying settle it, but if which is what the government has to do, but if the claimant knows that the government can't even answer a defence, they're not in a very strong position to settle advantageously. And of course, this can gather momentum. So, of course, I understand why it's not very attractive, but it is, I think, necessary. And in terms of the safeguards, not only are there the ones in the bill as amended, provided those amendments remain, but there's also a specific invocation of Article 6 of the European Convention on Human Rights, probably unnecessary because, of course, all our law is now subject to that convention. But this is yet another way of ensuring that before a decision is made or before the proceedings are completed, the court is satisfied that the normal safeguards which Article 6 provides have been satisfied.
Can I just challenge Lord Folkes, regrettably, because it's been such an amicable discussion so far, but the government does not have to settle these cases. At the end of the day, it is for a claimant in civil proceedings to actually prove their case, albeit on the balance of probabilities. But nevertheless, it has to prove their case. It is for the government not to seek to introduce evidence which may be tainted in a particular way. And if that sends a message loud and clear to other governments, as, for example, the prohibition on using evidence obtained under torture should do, that you don't actually seek to gather evidence in any event, or certainly not seek to use it if it's tainted in some way, then that is a wholly beneficial outcome of this, because it means that justice will be that much more transparent.
You're listening to The Voice of Russia in London. I'm Vivienne Nunes, and today we're discussing the government's push for secret courts. I'm joined by Lord Folkes QC from the Joint Committee on Human Rights, Stephen Tall from the Liberal Democrat Voice, and Keith Best of Freedom from Torture.
It's worth just picking up on the case that prompted all this, which of course was Binyam Mohammed and one of the Guantanamo detainees, who was subject to extraordinary rendition, to appalling torture, to genital mutilation, and this was covered up. And the evidence only came to light when an American judge allowed evidence that had previously been suppressed within British courts. And that was how we found out the truth of the fact that the British government had not been disclosing all that they should have been about the policy, the complicity of the British government within extraordinary rendition. And what's interesting about that, actually, is that the government did settle, but it settled under the existing system even before it had pressed its case as to whether it should be allowed within the CMP, the secret court procedure. It settled before the Supreme Court had ruled on whether that should happen or not. So it chose to settle It didn't have to settle at the stage it did. And I can't prove, I suspect the reason it did was that it knew its case was very weak. And so that's the fear about secret courts, is that these kinds of issues, which only come to light little by little when information often overseas is disclosed, not in this country, but information overseas is disclosed, comes to light, that's when we start to unearth the truth about what's going on. Now, I don't sound conspiracy theorist about this at all, because I take the point that the original intention is that these should be used in very limited number of cases. I take that point and I accept the government's good intentions about that. But we also know what happens with legislation once it's passed, which is that you get creep, you get legislative creep. It happened with the RIPA Act as well, the RIPA Act, where originally in there for good reasons, but now used by local councils increasingly for reasons that are very covert to put surveillance on citizens in a way that was never intended when the legislation was first passed. We see it with anti-terrorism legislation as well, which is then invoked by the police to throw protesters out of Labour Party conferences, for example. So we see how legislation is passed with the best of intentions, that it will be very limited, that it will only be invoked in particular circumstances, and what happens time and time again is that gradually those reasons get forgotten, and that because the legislative power is there, it is used, and it is gradually increased, and it all happens through whispers.
Lord Folkes?
I think this assumes the judges are somehow going to be complacent about this, and that they're simply going to say, oh, well, the legislation's there, let's go ahead and do this. That's not my experience of courts. I think judges who have this idea of open justice very much in their DNA are going to be very reluctant to be anything other than very questioning of government evidence, particularly if they perceive there to be a disadvantage to a claimant in the circumstances have been very well described. So that, yes, it is a strong theoretical point, but I think the practice is such that I don't have these fears that many have.
But of course, the more the judiciary remains independent, the more certain politicians claim that they are actually making the laws themselves and they are usurping the position of the legislature. And you end up with, in effect, mission creep, where the government then turns around and says, well, the judges aren't applying this in the way we intended it to be applied, therefore we must amend the legislation. And it becomes even more draconian. And that's my fear in this matter, however this bill turns out to look, whatever it looks like, in the form of a final act of Parliament.
Well, Keith calls it a fight. You could call it a healthy tension, which is part of our constitutional and the constitution and the separation of powers. And of course, it would need Parliament to approve a change in the legislation in the circumstances that Keith provides might happen. So that I don't see it as nearly in a gloomy a way as he does.
I think that the worry always is that what starts off with good intentions ends up with bad consequences, and that's what I fear here. You mentioned the bill being Kafkaesque at the start. I mean, Kafka was a warning, not a manual, and I think what the government is attempting here does risk compromising the basic tenets of our system of justice, which is an adversarial one. So you have uneven-handed justice, and that's not something I believe can be fair, free or equal.
That's all we have time for today. We'll all be watching closely as the Justice and Security Bill allowing for secret courts returns to the House of Lords for its third reading soon. In the meantime, I'd like to thank each of my guests for joining me at our London studios today. Lord Folkes, QC from Parliament's Joint Committee on Human Rights, Stephen Tall from the Liberal Democrat Voice, and Keith Best of Freedom from Torture. Thanks all for your time. You're listening to The Voice of Russia in London. Next up is the news. You're listening to The Voice of Russia in London. I'm Vivienne Nunes, and today we're discussing the British government's plans for so-called secret courts. Secret courts are what the media has called closed material procedures. Although secret courts makes a catchy headline, the official name gives more of a clue to what they really mean. Under a CMP, part of the case material would be closed from one party. That means they won't get to see all the evidence against them, and neither does their lawyer. Only a specially vetted advocate would have access to the material and then represent them in court. That might sound Kafkaesque, and it's got libertarians and legal experts up in arms. But the government says the precautions are necessary in cases that contain highly sensitive information relating to national security. And while the closed material procedures might not be...
The proceedings were such that they were not seen and publicised in the normal way.
Don't the existing measures used to keep sensitive material out of the public domain, though, such as suppression orders or public interest immunity orders, suffice?
Well, the trouble with PII, although it works quite well, it puts the government in a dilemma, because if a judge decides that the material is too sensitive, balancing up that interest with the interest in open justice, the government can then say, right, well, we can't adduce this.
Heard by CMPs if this legislation currently before Parliament is passed, and I see you've got a copy of the bill in your hand.
I have. It doesn't say what sort of cases, but the cases which would be under CMPs would be those that involve, in the government's view at least, revealing evidence. At least part of the case would involve consideration of matters where national security was involved. And in order to defend themselves properly, they would wish to rely on that evidence. They couldn't do so unless
the ideal, at least they allow for some form of justice for cases that are currently settled out of court. Joining me to discuss this conflict between open justice and national security are the QC Lord Edward Foulkes, a member of Parliament's Joint Committee on Human Rights. Also in the studio is Keith Best, a former Conservative MP and the Chief Executive of Freedom from Torture, and Stephen Tall, the co-editor of the Liberal Democrat Voice. Gentlemen, thank you for joining me. I'd like to start with you, Lord Foulkes, because you've spoken in favour of closed material procedures. First of all, what sort of cases would be